Hi, everyone. We are back. We're still talking about the steps in the process, but we are going to talk about specifically the steps of the jury. So we talked about all the different steps in the whole system. This lecture, we're going to specifically look at the jury and the jury system and the jury's duties and things like that. Okay, so we'll start with this little riddle. I kind of already gave you the answer. My job is more important than the judge's job. I decide who wins the case. Who am I? So hopefully based on what I said, you know that you're the jury. So that is what we're going to talk about in this lecture. We're going to talk about the jury system and how it works and how it functions and everything like that. So the first question is, why do we even have a jury? So we have a judge who acts like a referee. Do we need a jury? Why do we need the jury system? Why can't we just let the judges make the determination? Well, there has been many reasons over the years of why we think the jury system is really important. Number one, if we allow the judges just to do it, we're allowing the government a lot of power because the judges work for the government. Remember, a jury is private citizens. So in order to keep the government from just starting to determine their political enemies or something are guilty, we want to have citizens that make that decision to help prevent governmental oppression. We want the jury then to ultimately make the determination of the facts and determine whether or not the person's guilty, not the government. We also want a representation of the community. So we want the defendant to be judged by the people that are in his or her community so that there's a fairness to it. Another reason given for the jury system is that if you require people to sit on a jury, it educates them about our court system, which is really important. We want people to believe in the system and believe that it's fair and believe that it's legitimate for rule of law. Remember, if we believe that a rule is fairly created and fairly enforced, then we're more likely to follow it. If we require people to serve on the jury, then they're educated about the system and they're going to feel more confident in the system. And then it symbolizes that rule of law, okay? So have we always used a jury system to determine guilt? Well, not always. There have been different systems that have been used throughout history. So we've had what are called trials by oath. Trials by oath were when you had to get a witness to come and testify at trial that they would swear that the person was innocent. So think about the police coming to your house and saying, would you take the stand and swear that your best friend did not commit this crime? If you could not get somebody to testify and swear under oath, then the person was found to be guilty. Now, remember, this was a time when it was super, super strong religion, and people strongly believed if they lied under oath, they were going to spend all of eternity in hell. So it wasn't quite as easy as it may be now, because you had to get somebody that would swear. And if they swore and they were wrong, they had severe consequences. Another way that we used to try people and determine guilt was what we call trial by ordeal. And the idea was that you had to pass some sort of ordeal or challenge. And if you did, then you were found not guilty, okay? So if we dunked you underwater and you don't drown, then you're not guilty, okay? If we light a fire around you and you don't burn, you're not guilty. The idea is that God would never allow an innocent person to die. Okay, so God would protect you and keep you from dying because you were innocent. So that was another way that we had trials or determining guilt. And then we have trial by combat. So if you watched Game of Thrones, this was always a big part of Game of Thrones. You could fight, and whoever won was the person that was innocent, right? Because God would never let you lose if you were innocent. So we would allow these trials by combat. Okay, now what are some of the similarities within our legal system? We still require people to take oaths. So witnesses that take the stand have to swear an oath. So we still kind of use that concept to a certain extent. And we still have what we call character witnesses. You can call people that can testify that what your character is, that you're a good person. So those kind of both tie back to that first oath. We still have somewhat trial by ordeal. If we have DNA evidence, that's kind of like you passed an ordeal, so you're not guilty. Sometimes lie detectors, most courts don't allow those, but that could be the ordeal. And then you could argue that our whole system is trial by combat because it's an adversarial system. The prosecutor, the defense, they're duking it out in court. The truth will rise at the end of the conflict, okay? So yes, there are many different ways we still integrate these concepts. Now the question is, do any of them really ensure order and justice? Does it assure that the person truly is not going to be convicted if they really are innocent? I don't know, it's kind of a judgment call that you would have to make. Do you think these are enough to protect innocent people from going to jail? Now, the actual trials by jury began in England. So it came about in an idea in England called the Magna Carta, which was created to protect the people against the kings and queens having too much power. So that was the first time in England, and remember, England's laws really came over and became the basis for all laws. That was the first time that they really had these trial by juries in England, okay? And they, not that they had them, but that they were required. That law was brought back to our country when our country was formed, and they continued that idea in federal and state courts. So they believe it's really important to have the right to a jury. It's in our Constitution. And the whole idea was it is necessary to protect against governmental oppression. We don't want judges, governmental officials to have too much power in our system. We rather somebody be judged by their peers. So what constitutional amendment requires a jury to occur at a trial? That's the Sixth Amendment. So all rights to a trial by jury is set forth in the Sixth Amendment. Now, when we talk about juries, there's actually two different types of juries that we have. So we already went over grand juries when we went over the steps in the process. Remember, a grand jury is a group of around 23 people, and they are reviewing what the police did to assure that there's probable cause to keep it going towards a trial. So remember, a grand jury occurs early in the process. It's just the prosecutor presenting evidence, and then the grand jury has to decide if there's enough to allow the trial to proceed. If they think there's enough evidence, remember, they issue an indictment. If they don't think there's enough evidence to continue to trial, then they issue a no true bill. Now, once you get to the trial, you have the right to a Pettit jury, a criminal Pettit jury. This is a much smaller group of people, anywhere from 6 to 12 people. And this jury is actually deciding whether or not the person is guilty. So I know this is kind of hard to see, but it really goes through the differences between the grand jury and the Pettit jury. So you might want to take a few minutes just to kind of read it over so you really firmly understand what occurs. So remember, grand jury, only the prosecutor presents evidence, but at the trial, for the trial jury, both sides have a chance to argue. Grand juries are secret, trials are not. Grand juries more people, trial juries less people. So spend a few minutes just kind of reviewing that so you truly understand the distinction between the different types of juries. Now, we're going to look at Pettit juries because we already kind of talked about grand juries when we went over the steps. So the Pettit jury is the trial jury, and it usually is anywhere between 6 and 12 people. At the federal level, it has to be 12. Now, for a jury, they all have to agree on the decision. So all decisions have to be unanimous. That means every single person on the jury has to decide guilty, or every person on the jury has to decide not guilty. You can't even have one person disagree. Every single one of them has to agree. And if you've ever worked with a group, it's often very hard to get everybody to agree on one thing. So that's what makes it challenging. And we hope that that's a protection against innocent people being convicted. So what does the the Pettit jury actually do? They listen to all the evidence that's presented at the trial. So the prosecutor is going to present evidence, the defense is going to present evidence. They have to look at all of that evidence and decide whether they're going to find the person guilty and convict them or find them not guilty and acquit them. That is their job. Now, how do we pick people to serve on the Pettit jury? Where do we get the names to get people to show up and be on the jury? Well, we can use all kinds of different lists. Sometimes they use car registration, they use voter registration, they use phone books, they use insurance records, and that's what they do, and they pull all these people in, okay? And once they pull them in, we have to then pick out of that group, we have to pick who's gonna be on the jury, and that's called voir dire, okay? So voir dire is the process of actually picking the jury and who's going to serve on the jury. So what is the purpose of voir dire? To narrow out and get rid of people that are already biased. So we have this whole questioning process. We bring all these people in and we ask them questions, and we want to weed out the ones that are not going to be fair. We want to weed out ones that have bias already and already have their mind made up, because we want the jury to start from scratch and make up their opinion based solely on the evidence that's presented at the trial. We want it to be non-biased. We don't want any preconceived notions on guilt or innocence. We want the jury to start fresh. So we're going to ask them a series of questions, and during that questioning, we're going to try to weed out who we think should not be on the jury. So let's talk about the jury selection process. The first step is jurors are chosen from a veneer, okay? So the veneer is that big group of people. So the county could call in 800 people. That's the veneer. It's all of these people, okay? So we have this big group that is required to report. Once they report, so the veneer is this large group of people, and it's supposed to be a cross-section of all of the community. So it should proportionally represent the diversity of your community, age, race, sex, gender, all of those things. Now, where do they get the names? I kind of already mentioned that. For the veneer, they get names off of lots of different things: tax records, voters registration, car registration, phone books, insurance records. So they get all of these names, and they send them out what's called a summons, jury summons, and they are told you have to come to court on a certain day, and you will be part of the veneer. When you show up as part of the veneer, you're going to have to fill out what's called a juror questionnaire. They're just going to ask you some basic general background information: age, gender, where you live, how long you've lived there, what's your current address, do you rent or own, what is your marital status, what do your children do, do you have children, how many, what do you do, what do your husband or spouse do, what do your children do. So they just want as much basic general information about you as a person that they possibly can get. Now, this is just general information, but let's say you were choosing a jury for this case. So Brian David Mitchell went on trial for kidnapping 14-year-old Elizabeth Smart and keeping her captive for 9 months, sexually abusing her. He was a very extreme religious views. He believed he was God. He believed he was a godlike figure. So she was his wife, and she was, wonderful because she was his wife, even though she was a little girl. He would show up to court singing hymns. He believed it was the end of the world, so it was his job to create children with her. So although we would want to know age, name, race, gender, all those things about the juries, potential jurors, what else, if this is your case, what specific questions would you want to know? Because you want to get at bias. You want to see if the jury has swayed any particular way on certain issues. So sometimes there's additional questions. Do you consider yourself a religious person? What is your religious affiliation? Are there religious groups that you think children should not be brought up in? If you attend church, do you think it's more, do you feel are the most important things you learn from church? Have you ever been a member or contributed to a group opposed to a religious group or sect? So you're gonna, since religion is playing a significant role in this trial, you want to also get at questions that are going to delve into people's personal biases on those particular issues. So we have our veneer, our jury pool. They all show up, they all answer these questions. Once they ask a question, they answer all those questions, then about 30 at a time are removed and they're put in the courtroom. And while they're put in the courtroom, then the prosecutor and defense start to ask specific questions of those 30 and try to decide, are we going to be able to keep any of them as jurors? So they're going to start out with very general questions. We can't have anybody that has biases or are predisposed to their opinions already. So the initial questions are really going to get at, do you know anybody involved in the case? Do you know the prosecutor, the defense, the defendant, anybody related to them? So they want to get rid of people that know anybody involved in the case. Have you read the media? Do you already know how you feel about this case? If you're already biased, they want to get rid of you. If race is an issue, are you part of any white supremacy group or something like that? You would be gone, okay? So those are all reasons to kick people off right away. Once we get rid of those biases, people, then we have a pool of other people that are left. Then out of that group that's still left, we can wheedle that group down till we have about 14 jurors. So those secondary questions, religion and things like that, we're going to ask those questions along the way and try to narrow down who exactly should be the 12, 6, 12. It says 14 because sometimes you pick alternates. So in case something happened to one of your jurors, you have somebody else that can stand in. Now, if you're not picked for that, you let go and then you served your jury duty till the next time you have to show up. If you are picked, then you proceed to the trial. Now, what if it's a death penalty case, which we don't have in New York, but if we did, then can you serve on a death penalty jury if you've already formulated an opinion on the death penalty? So this has come up and we have what's called a death penalty qualification. What the courts have said is, if you are adamantly opposed to the death penalty under any circumstances, you cannot serve on a death penalty case because you've already made up your mind. If you agree with the death penalty, you can serve, because it doesn't mean you're going to find it in this case. It just means you are open to giving that as a possible sentence. So when we ask those initial questions, if it's a death penalty case, we have to decide right away, are you even open to giving the death penalty? If you are adamantly opposed to the death penalty, you cannot serve on that death penalty jury. Now, we said we can get rid of people that are biased. That is what we call a challenge for cause. So we have certain ways as an attorney to kick people off that we don't want to be on the jury. Now, we kick them off if they're biased or already have their mind made up and cannot be fair. That's a challenge for cause. So we can kick out anybody that doesn't qualify. There's no numbers. You can have as many challenges for cause that are necessary to get rid of anybody that would be biased. We also give what's called peremptory challenges. Peremptory challenges are the ability of one of the attorneys to just kick somebody off without a reason. Okay, I don't like juror number 2's hair, so I want him off. That's a peremptory challenge. You never have to tell the judge why you don't want them. You just say, I'm using my peremptory to kick off this jury. Now, what's important to remember, though, is it's strategic, because with peremptories, you only have a certain number. And when you're out, you're out. So if you use them all and somebody comes along that's even worse than the person you used it on, you're stuck with that person. So it's kind of a game of chess. You kind of have to really figure out when is it important to use it and when is it important to hold on to it. Okay. Now, there has been a lot of questions, and if you follow the news, there was the case of Ahmaud Arbery, who was killed in Virginia. They just picked that jury. And it ended up being in a 50% minority community. Only 1 juror out of 14 is African American or Black. And so people said that the defendants are white, and they're the ones accused of killing Ahmaud Arbery. And so the argument was that the defendants used their peremptories to get rid of all Black people. So that has happened in many cases. And so there are many people that say we need to eliminate peremptory challenges. They're always going to be used in a racist or biased way. No matter what people say, they're going to be used in this negative way. So we should just get rid of them all the way, okay? No state has done that, but, well, California is actually did, but no, New York hasn't done it, okay? So there have been some movements towards getting rid of peremptory. Now, you can challenge, so we said no reason. You don't have to give any reason for using a peremptory challenge. There have been court cases, though, that say you cannot use them to kick out minority groups, and then Jeb says you can't eliminate genders using peremptories either. So what happens is if the one side uses all their peremptories and seems to use them in a way that's trying to eliminate a minority group or all the females or all the males, the other attorney can do what's called a Batson challenge. And what that says is, we know that the attorney didn't have to give a reason to kick them out, but the way they use them, it's creating an appearance of discrimination. If the judge agrees that there is an appearance of discrimination, then they go back to the attorney and say, okay, now you do have to give a reason other than race of why you kicked this person off. So they have to have a legitimate, non-discriminatory reason that they can articulate to the judge for why the person was kicked off. If they can't, the person's put back on, okay? If the judge believes there are other reason, then they can use their peremptory challenge. Now, they're only going to ask those reasons if the person claiming a Batson challenge can show some evidence that these were used in a discriminatory way. But you can see how they could really be abused and why there are some challenges to get rid of them. Okay, so the last thing I want to talk about is what we call sequestering jurors. Sometimes in very high politicized cases, we don't want the juries going home. The media, the attention, the riots, the protests, all kinds of crazy things. We don't want them influenced by outside sources. So sometimes we sequester the jurors. That means that we put them up in a hotel. So the entire time that the trial's going on, they can never go home. They have to stay in the hotel. They take out the TVs. They don't let them have newspapers or media. They take their cell phones, and they don't allow them to have any connection to the outside world until the trial is over. It's very expensive because you got to pay for their food and their board and all that stuff. And it's also very infringing on somebody to have to do that for jury duty. So it's not used very often, but in extreme cases, it can be used. Okay. So the last thing I want you to do is just think about the process, just to kind of give it some thought. So if you were the attorney and you are picking a jury for a young mother accused of failing to provide proper care and supervision of her children, her child wandered out of her house and into the street and got struck by a car. So the woman is being charged with negligent care and supervision of her child. You are the attorneys in the case, okay? So if this was your case, I want you to brainstorm who you think would be the best juror for your case, okay? So I want you to start thinking as a prosecutor first. If you were trying to convict her, who would be jurors that would be most sympathetic to your arguments? So think about age. Do you think older or younger people would be more sympathetic? Think about race. Do you think it's a racial issue at all? Think about socio and economic status. Think about occupation. Think about if they have children or don't have children. Think about gender, males or females. So think about all these criteria that you would think would be the best juror for you. It is somewhat stereotyping, but this is what you do. You kind of brainstorm and try to pick out who you think would be your best bet as a juror. Then once you did the prosecutor side, switch to the defense. So who would be your best defense witness? Age, race, gender, ethnicity, socioeconomic status, jobs, income, where they live, anything that you can think of, religion. What would be your best person? So when you read your scenario, think about who the attorneys would really want on their jury. Okay. So after you've done that, I have posted a video. It's called You Be the Judge. If you would like, you can watch it and you can form your own deliberations. So it's a little mini trial. You can watch what happens, and then you could decide if you were the juror, how would you decide the case? It's not an assignment or anything, but it's interesting. Okay. So that's the end of our lecture for juries. Don't forget, you have a Chapter 8 discussion. Your Chapter 8 discussion requires you to deliberate. So you have to read all of the facts and you have to deliberate on the case. So I hope you enjoyed the lecture and I will see you soon.